Hello guys, so let's begin. I have to start from some common legal terminologies. So there is nothing as such to explain in this. You need to learn all these, and since these are common, generally used in parlance, so it's just that you must be aware of what these mean. Okay, so plaintiff is the person who files a civil case against another. Defendant, against whom the case has been filed, and it comes from the word defense. So he takes the defense of the case. He defends himself. Okay. Plaint is the whatever complaint is filed, okay, whatever document which is filed by the plaintiff, which lists down that what is his violation of right, what right has been violated, what he wants to claim as a relief or remedy from the court, okay, and what the other person has done, details of that other person against whom he is filing that. So all that is given in that plaint. And when someone is filing something against you, like in a classroom, even when someone complains against you, you are called upon to say something on your behalf. You have to defend yourself, right? So whatever you say in your defense, that document is known as written statement. Okay, this is an example just to explain you guys. So reply to the plaint, and it is filed by defendant. Plaint is plaintiff, defendant is written statement, shortly termed as WS. Fine. Appellant is who files the appeal. Respondent is against whom the appeal has filed. Okay, respondent who responds to the appeal. So it is this is how these terminologies have to be inferred. Prosecution is victim's side in criminal case. Okay, and you may have heard the term public prosecutor. So the lawyer from the government side who fights the victim case. Why? Because a crime is considered to be a wrong against the whole society, not only against an individual who is directly affected by that crime, but also against the whole society who are indirectly affected. Okay, then defense, that is accused. अक्यूज़ के अगेंस्ट ऑब्वियसली फाइल होगा कोई क्रिमिनल केस, वो अपने आप को डिफेंड करेगा. सो दैट इज़ बाय द डिफेंस लॉयर और डिफेंस. Application, document seeking an urgent instant relief. It can be filed by plaintiff or defendant. Now when the case is of an instant relief, so the instant relief can be either by plaintiff or the defendant, and here nobody is criminal, right? So he can also claim the relief. Moreover, for even defense or for criminals, for that matter, you may have heard about mercy petition or pardon from president, right? So these are also the reliefs sort of which are there for criminals. It can be filed with plaint or WS, or even in between the proceedings. Application is always filed under a plaint. The person who files an application is applicant, and person against whom it is filed is respondent. So don't get confused between appellant and applicant. Appellant, one who files appeal. Applicant, one who files the application. From the word itself you can infer. Interim means for the time being. Interim session सुना होगा. Interim leader. Arrested and accused person. So arrested means who is in the custody of police during investigation on the case, right? And it is on the basis of suspicion that you may have committed an offense or the wrongful act. So I am arresting you so that I can question you or interrogate you during the investigation process. Okay, and it may happen that during interrogation or after it, it is found that he has actually committed or he has not committed, because he was arrested on the basis of suspicion. So suspicion may result into something positive or negative. If it is positive, that means he has committed. If it is negative, then he has not committed, and he is not an accused person, or he is acquitted, right? So accused person is when there is concrete evidence that he might have committed the crime. Okay, and now trial has to be initiated against him. Means there are documents, there have been evidence on record that point to the direction or that point to the projection that this person has most likely committed the crime. Evidences are going against him, so he may said to be an accused person. He will be guilty or not, that will be decided by the end of trial proceedings by the court, and all these evidence gathered and arrested and everything, that is done by police. Now we come on to types of jurisdiction. So jurisdiction means what? You may have heard this term. The extent of power of a court to entertain suits and applications. A court of competent jurisdiction is the most common expression which is used, and you may find it in various books and texts. So jurisdiction means the competency, the capacity, or the arena or the magnetic field sort of thing concerning powers of a court to entertain the type of suit, okay, beyond which they cannot go. If suppose their jurisdiction on the basis of money is, that is pecuniary jurisdiction is 50,000 rupees, then they cannot go beyond and take the suits which have the value of more than 50,000. Okay, that will be known to be ultra vires, and the decision will be erroneous on the ground of lack of jurisdiction. Okay, and so types are: territorial means physical area or local limits within which a court exercises its jurisdiction, like district court. Okay, the High Court of Allahabad cannot take the case of High Court of Bhopal, right, because it's outside its jurisdiction. Pecuniary jurisdiction defined on the basis of money claims. Now this money claims, if I give you an example, for suppose there is a house, okay, and this is subject matter of dispute. Subject matter of dispute means around this house dispute revolves, the main issue revolves. That is, a person A claims that he is the owner of this house. Meanwhile, B, his brother, claims that he is the owner of this house according to will. Okay, will means जायदाद की वसीहत जिसको बोलते हैं, है ना. So, and the value of this house is, for suppose, 50 lakhs. Okay, and there is a court which can deal with matters of around 20 lakhs only, very hypothetical example. Then this matter cannot go to this court even if it is in the jurisdiction, because pecuniary value is not suggested. Then original jurisdiction. Original means, wherever you find this term original, means the first time hear and try a case. Okay, the first time. Original means सबसे पहले केस वहाँ ही जाएगा. Then appellate means appeals. As to subject matter means civil, criminal, family law, all these, which depend upon the type of cases that can be heard. Okay, tribunals can also come under this, which are made for particular laws concerned. Now we come on to res sub judice, res judicata. These are common terms which are used in civil suits as per CPC. Okay, so I will in short term say CPC instead of this civil procedure code. Fine. So res sub judice is in section 10. Please learn the sections. I don't need to mention this again and again, that wherever sections or articles of constitution come into picture, you need to learn them. There is no other way out. Res sub judice. Now, res sub judice means, for suppose there is this court A, okay, there is this court B, two parties X and Y have a dispute of a property, say P, okay, and these parties have already filed their case related to this property in the court premises A, in the court A. Now, as you know, cases in India, they are long durations, right? So it is pending over here till the time what they think is, okay, now this is pending, so Y goes to X. This case was X versus Y, here Y versus X, okay, and he goes to court B, that maybe this court will grant him relief earlier. He wants instant relief, so he goes in court B. Now what happens is, one case between the same parties X and Y, okay, for the same subject matter, that is property P, is pending in one court. Same case goes between the same parties for the same subject matter into court B. Now what will happen, there is repetition of case, right? And even if this court takes it up, what it is causing? Repetition and waste of time of court, knowing the fact that there are many pending cases from many years and there is a huge pile of pending cases kept, and still you are wasting the time of court by instituting a fresh suit for between the same parties of the subject matter in a different court when you have it in one court already pending, right? So to avoid this, we have the principle of res sub judice. Now read what it's given in your book. Where the same subject matter is pending in a court of law for adjudication. Adjudication means deciding upon, okay, between the same parties, any other court is barred from entertaining that case as long as the first suit is going on. So the court B will be barred. Barred means stopped. It will not be allowed to see or to do the trial of the fresh suit as long as the first suit is pending. Let the first court decide the suit, then you may file a fresh suit in a different court if you are not satisfied. But before its decision come, you cannot go to another court for the same suit, for the same subject matter between the same parties, just to cause multiplicity of proceedings or waste the time of court, right? When huge pendency, huge pile of cases are already pending, okay. So the objective of this principle is to avoid multiplicity of cases and to save the time of court. Now I give you one more example to make it clear to you. Like these you will study in CPC in more detail, but just to clear your concept, one more example over here. For suppose there are two parties X and Y. This is court A, this is court B, fine. And for the property dispute P, for the dispute of property P, X versus Y is pending in court A. Now X owns another property Q, okay. Y wants to purchase this property as promised by X few years ago, but now X is refusing, saying that already one case is pending against you, now I will not take another chance, okay. So Y files a suit against X in court B for property Q, okay, saying that he has breached the promise, fine. Now look here, now if you look over here, then what it is, parties are same, but the property in dispute is different. Over here it is P, over here it is Q, so subject matter has differed, so this suit will be allowed, fine. So you have to see the parties should be same and the subject matter should also be same. Also this res means thing, okay, and sub judice means pending, is, or you can say is still in adjudication, means it's still for decision, for resolution of disputes, fine. This is pending, Now you come on to res judicata, that is section 11. Now again, res means thing and judicata means already decided. Okay, so this is the meaning of this term, thing already decided. Now what is the thing? A dispute. Now if a thing is already decided and for the same thing you are again filing in a different court or in the same court for that matter, now what will happen? Maybe that the case goes to different judges. Different judges means different people, different point of view, so their way of looking into the situation may be different. Whatever decision they will give, that will be different. So for the same dispute between the same party, same facts and circumstances, two different decisions will be there. Now the question will be, or the confusion ruckus will be, that which decision is correct, which should you follow, right? One party, suppose decision A has come in favor of party X, decision B is come in favor of party Y. Now obviously X will like to follow the decision A, Y will like to follow decision B, and each other they are forcing to follow the other decisions. Y is forcing X to follow B decision, right? Because it's in his favor. So to avoid all this chaos कि हम कौन सा डिसीजन फॉलो करें, कौन सा सही है, हमारे पास सेक्शन 11 है, दैट इज़ रेस जुडिकेटा, operates as a bar to the trial of a subsequent suit on the same cause of action between the same parties. Cause of action means why the action has been initiated, action that is filing a suit. क्यों suit file किया गया था, what was the cause of it? Okay, what was the cause that the party, that is plaintiff, came into action of filing a suit? In legal terms it means there was a legal right that existed, okay, and you had violated that legal right. Fine. So in legal terms, cause of action means there was a legal right that existed and there has been a violation of that legal right. Then only the plaintiff or the person comes into action of filing the suit because his legal right was violated. Okay. Otherwise you can just understand for your common understanding that cause of action means the cause of initiating the suit. Then it is based on the principle of finality of litigation and conclusiveness of a decision. Means whatever litigation means, whatever the case has been decided, finally you have to be confined to that. You cannot go and knock the doors of court again and again for the same dispute. ये मेरा सॉल्व करो, नहीं आप दूसरे तरीके से सॉल्व करो, आप दूसरे तरीके से देखोगे तो शायद अलग डिसीजन आ जाए. नो, इट विल अगेन वेस्ट द टाइम ऑफ कोर्ट एंड मल्टीप्लिसिटी ऑफ proceedings. There are so many other cases pending, so many other people who want justice also, they also want it to be delivered soon, and you are just wasting their time, court's time and everybody's time, right? When there has been a decision, maybe in your favor or not, there are other remedies, there are other reliefs that you can claim. You can go for appeal, reference, revision or what not, but you cannot try another suit, a fresh suit, to start from square one, to start from the very beginning, between the same parties for the same subject matter, right? Conclusiveness of a decision means finality. Whatever it is, now it is conclusive, it has to be concluded, it is final and you have to obey it. Founded on the principle of justice, equity and good conscience. Good conscience means good reasons or values, and equity means like where there is a loophole or where there is no law. Maybe that there is lacuna of law, or the law which is there, it is not sufficient to apply in a particular case or circumstance, then equity comes into picture. Common law or just and whatever it is reasonable as per the situation, the court may give decision according to that. What are the examples given? Let's see. X sues Y for breach of contract. Suit gets dismissed. X now files a suit for damages for breach of contract. Suit for damages is barred as it is res judicata. Now see how. Now see why it is res judicata and not sub judice. Tell me. Because it is not pending. Sub judice means which is pending, right? And here it is dismissed, means there is a finality given to it, that I dismiss your petition. और ये dismiss ऐसे तो नहीं हुआ होगा, कुछ डिस्कशन हुए होंगे, कुछ एविडेंस ऑन रिकॉर्ड देखा गया होगा, और ये कंक्लूड किया होगा कोर्ट ने दैट इस कोर्ट में इस केस में दम नहीं है, राइट, और इट इज़ नॉट करेक्टली फाइल्ड और वट एवर द रीजन्स आर, इट वॉज डिसमिस्ड, तो उसके लिए भी कुछ रीजन्स साइट किए होंगे जजमेंट ऑर्डर में, राइट. सो it is judicata because it is already decided that the petition has to be dismissed. Okay, if it is pending, then it will be judice. And now see why it is res judicata. Is it between the same parties for the same subject matter? X sues Y. X for breach of contract against Y. So again same parties. Breach of contract. Okay, if nothing is mentioned, that means it is talking about the same contract, so same subject matter. Also it is for breach of contract, this is for damages. You may find that these are two different subject matter. No, the thing is breach of contract. Okay, अगर दूसरा कॉन्ट्रैक्ट होता तो यहाँ पर उन्होंने लिखा होता दैट फॉर अनदर कॉन्ट्रैक्ट, बट इफ इट इज़ नॉट रिटन दैट मीन्स दे आर टॉकिंग अबाउट द सेम कॉन्ट्रैक्ट विच हैज़ बीन ब्रीच्ड बाय द अदर पार्टी. नाउ why damages and breach of contract are the same thing? Because already for breach of contract you can claim the relief of damages. So when you file a suit for breach of contract, what next you claim is damages or the specific performance. Like if you have promised me to deliver this much and now you have breached that promise, I want you to perform it. So that is specific performance, that whatever was promised, you have to fulfill that or perform that. Okay, now next example, X files a case for negligence in service against Y, his employer. While his suit was pending, he also files another suit for claiming accounts from his employer. Now the subsequent suit is stayed as the matter is res sub judice. Case of negligence, X versus Y. This suit is pending. Another suit for claiming accounts from his employer. Negligence in service means maybe he has misrepresented some accounts or he was not careful in maintaining those accounts. Okay, that's why it's between the same parties and for the same subject matter. Negligence in what? Negligence in service. So he may have mentioned that what kind of service or what particular negligence has been done. Okay, and suit for claiming accounts, so maybe that negligence is in this regard only against the same party and it is pending, it is not decided, so it is sub judice. Once the first suit is determined, the matters raised in the subsequent suit would be res judicata by reason of decision in prior suit. So whatever decision has been come in the prior suit, if it is determined means decided, then whatever you are raising in the subsequent suit, provided that it is between the same parties for the same subject matter, then it will be barred by res judicata. Okay, that whatever decision has come, it is final, it is conclusive, and now you have to obey that. Difference between res judicata, res sub judice simple है, जो मैं बोल भी चुकी हूँ इतनी बार, that judicata means already decided, judice means pending. Okay,